You sued your doctor for medical malpractice, claiming that his carelessness caused you harm and injury. Now, during the course of your lawsuit, you will be asked questions by the attorney who represents the doctor or doctors whom you have sued. Is that attorney who's going to question you during this process that we call a deposition, is that attorney the same lawyer who's going to be representing the doctors and the hospital at the time of trial? Will he be the one who questions you and cross-examines you if your case goes all the way to trial? You want to know the answer? Come join me on this walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In all likelihood, the answer is going to be no. Now, why do I bring this up? I bring this up because some people get so focused on the attorney, on who the attorney is, and whether the attorney is nice when they question you during your pretrial question and answer session known as a deposition. You see, when you bring a lawsuit, the defense has an opportunity to go ahead and learn from you, to ask you questions, to find out in your own words exactly what happened, what you remember, what conversations did you have. The defense has an opportunity through their lawyer to ask you hundreds and thousands of different questions about how your injuries have affected you on a daily basis. And now that can take hours, it can take a day, sometimes it can take even more. So that process, that pretrial question and answer session, is what we call a deposition. Lawyers also call it an examination before trial. And this takes place way before your case ever gets to trial. It's part of the discovery process. Now, there are some defense attorneys who are the nicest people in the world. And you may think that's kind of odd coming from an attorney who represents injured patients, injured victims for a living. But the reality is that there are some defense lawyers who are wonderful human beings. On the other hand, there are some defense attorneys who I have clear choice words for that are not exactly appropriate for this video. Those are few and far between, but there are those types of attorneys. And those attorneys I can easily do without. My clients can easily do without. But once in a while, my client, when they are questioned, has an attorney who is not exactly the nicest person. He might be aggressive. He might be a bit nasty. He might be sarcastic. He might not believe anything my client has to say. Now, as you go through this pretrial questioning process, you, as the injured victim, as the injured patient, may think that your entire case rests on this particular attorney. You may think that this lawyer is going to be responsible for the defense side of the case throughout the entire litigation. You may think that when and if your case goes to trial, this nasty, obnoxious lawyer is going to be the one at trial who's going to question you. And you know what? In all likelihood, the answer is it's not going to be the same attorney. And let me tell you why. What happens in these types of malpractice cases is that the defense attorneys give these assignments to question you, the injured patient, the injured victim, the injured plaintiff. They give those assignments to typically the junior attorneys in the office. Why? Because there's very little downside and very little risk to allowing them the opportunity to question you. Plus, it also gives them great experience on learning how to question witnesses. You see, there's very little that they can do wrong. Why? Many times they come into this question and answer session with a checklist, a prepared typewritten checklist of those questions that they believe that they need to ask you during the course of your deposition. And many of these junior associate attorneys go through this checklist one by one to make sure they've asked all the questions on their checklist. Sometimes the better attorneys, the ones who are really paying attention, ask follow-up questions to the answers that you have given that are not on their checklist. But in any event, these attorneys are really going through their checklist to make sure they ask what they think are all the appropriate questions that they need to know. Many times, it is totally inaccurate for them to be asking you every single question on their checklist. And now, how do I know what questions they're going to ask? Well, after doing this for more than 34 years, I know exactly what questions they're going to ask. And if you want to learn more about that, I've created other videos that describe how I know exactly what they're going to ask. So getting back to the question that I raised in the title of this video, just because an attorney is nasty or obnoxious, and now you get this perception that this lawyer is a nasty, vicious person, and you hate him, and you hate everything about him, and now you associate him with the doctor and with the hospital and every interaction that you and your attorney have with the defense, you should know something. In all likelihood, this attorney who is questioning you during your pretrial deposition does not have the knowledge or experience to go ahead and represent the doctors or the hospitals at the time your case goes to trial. In all likelihood, if your case goes to trial, that will be handled by a senior attorney, most likely a partner in the defense lawyer's firm, somebody who clearly has experience, somebody who understands how to question a witness, somebody who understands that if they are nasty and obnoxious to you when cross-examining you, how that can often backfire in front of a jury. The better practice often is to be nice and pleasant and to show that there are inconsistencies in testimony. That, in my opinion, is a much better strategy. If the attorney who's questioning you during your deposition is nasty, is impolite, is not being totally professional, I will say something to the attorney. I will put something on the record to indicate that the attorney is being nasty or obnoxious or impolite or not professional. So why do I share this with you? I share this with you because some injured patients, some injured victims, go through their lawsuit feeling that the defense hates them and hates their case. They get the feeling that the defense does not believe a single word they have said throughout the litigation. They have the sense that every time they mention something about their injuries, that the defense attorney does not believe a single word they have said. Now, I will share something very important with you, though. The defense attorney, at the end of questioning you during your pretrial deposition, prepares a report. And the report is supposed to detail all the facts that he asked you about, that he learned about during this questioning. And at the very end of this report, he often will give an opinion about what type of witness he expects you will make at the time of trial. If he has pushed all your buttons, and now you've gotten excited, you've gotten angry, you've gotten upset during the course of your deposition, he's now going to indicate in his report that now he can manipulate you, and he did so by pushing all your buttons. And that is a very, very important thing for the trial attorney to know, because in all likelihood, the trial attorney will never have met you until trial. And by reading an opinion of the attorney who questioned you during your deposition, now he gets a better sense of what type of witness he can expect when he gets up to cross-examine you. Are you going to be polite? Are you going to be sincere? Does he think you're going to be believed by the jury? All of this is critically important. But don't think for a second that if the attorney was nasty, obnoxious, impolite, unprofessional, that's how it's going to be when your case gets to trial. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.